So in today's video, we'll look at examination of witnesses. So we'll first start by defining what examination is. So examination is the process by which witnesses are questioned in court. So every witness goes up to 3 stages. The 3 stages are examination in chief, cross-examination, and re-examination. So in examination in chief, it's done by the party who called the witness, and the purpose is to get their story out. Then after examination in chief, we go to cross-examination. This is done by the opposing party, and the purpose is to challenge and test the story that was told in examination in chief. Then lastly, we have re-examination. So this is done by the party who called the witness, and the purpose of doing this is to repair any damage from cross-examination. Okay, so now we can look at the 3 stages in detail. We start with examination in chief. So the objective of this is to obtain through the witness evidence that is relevant to your case. And this evidence should be presented in the most coherent and persuasive way possible. So you can think of examination in chief as telling a story. Let's say you've called the witness because they know something important. So your job as the advocate is to draw information from the witness in a logical and clear way. But then we have rules in examination in chief. The first one is the rule against leading questions. So the central rule of examination in chief is you cannot ask leading questions. So that's the general rule. So a leading question is a question that suggests the desired answer. These are yes or no answers. For example, an advocate can ask a witness, let's say they ask that the defendant hit you with his fist, correct? So that question requires a yes or no answer. But then where an advocate asks, what did the defendant do? That's not a leading question, that's a non-leading question, meaning it requires the witness to explain what they went through or what they saw. Yeah, like that. Meaning it requires an explanation, it's just not direct. Then, but there are exceptions to the rule against leading questions. First one is the formal introductory matters. Things such as age, address, occupation, such like that can be asked. Then the second one is undisputed or scene-setting matters. So if a fact isn't genuine in dispute, you can lead. An example of this can be where an advocate asks, do you recall the events of September 18th? So this sets the scene without suggesting anything controversial. Then the second one is identification of items. So when identifying physical exhibits already in evidence, such as let's say a weapon, a document, a piece of clothing, like some leading questions is allowed. But first you must lay a proper foundation. Then the fourth exception is for when you're dealing with a forgetful witness. So if a witness cannot genuinely remember something, you can ask leading questions to help refresh their memory. For example, an advocate can ask, does it help to remind you that this meeting took place in January? So this is forgivable. It's different from suggesting a contested fact. So we can now go to refreshing of the memory. So witnesses are human, and as humans, we forget some things. So the law provides some flexibility for a witness to refresh their memory, but with safeguards. So the general rule is that a witness may refresh their memory from a document, but only if the document was made by the witness, or it was made during the same time the witness had observed the dispute or whatever was happening. So a practical example of this can be, let's say, a police officer who investigated the crime scene made detailed notes at the scene the same day. Then 6 months later at trial, they can refer from the notes to refresh their memory. So provided that these notes were made at the same time that the witness had observed what was happening, then it is fine. So here you have the case of Richardson. So the court confirmed that a witness may refresh their memory from their statement any time before entering the witness box, so including immediately before giving evidence. Then in the witness box, cases on this are Magnum versus Hubbard and Ara versus Kelsey. So under common law, a witness may refresh their memory from a contemporaneous document while in the box, subject to the judge's oversight. So the opposing party then has the right to inspect that document and cross-examine on it. This is because a witness is reading from a document. The opponent needs to know what is in it. So the opponent needs to check whether it's genuinely contemporaneous and whether the witness is actually refreshing their memory or they're just reading a prepared script. Then the third one, is leaving the witness box. So here we have the case of Ara versus De Silva. So in exceptional circumstances, a witness may seek permission from the judge to leave the witness box to refresh their memory from a document. So this requires the court's express leave, and it's not done routinely. So now we can look at the rule against narrative. So what this means is that a witness cannot give evidence of their own previous consistent statements. So what this means is that you cannot say, I told my friend the very same thing 3 days ago to boost your credibility. So the fact that you said the same thing before doesn't make your current testimony more reliable. So this is because anyone can create a self-serving story and repeat it. So consistency alone doesn't equal truth. So this was seen in the case of Ara versus Roberts, and the accused tried to introduce evidence that he had previously told his father the same account was given in court. So here the court rejected this and stated that it was a previous consistent statement and therefore inadmissible. It's also seen in the case of Koch v. Koch and Koch, where a wife was found, or where the husband had found his wife with another man in the hotel room, and the wife had suggested that she could call her doctor so that the doctor can come and examine the wife and the other man. Then in court, the wife had tried to bring out this and said that she tried to call the doctor so that they can examine them. But then the court also rejected this since it was narrative. But then we have exceptions when previous consistent statements are admissible. So the first exception is recent complaint in sexual cases. So a complaint made by a victim of sexual offense soon after the incident and without prompting is admissible to show consistency. But it is not admitted to prove the truth of what was said, but to show that the victim's account has been consistent from the beginning. So an example can be, let's say Jane is assaulted on Saturday night. Then on Sunday morning, she calls her friend and tells her everything that happened. So at trial, Jane gives evidence. Then her Sunday phone call can be admitted as a recent complaint, showing she didn't fabricate the story. But then the conditions here that the complaint must be recent, it must be made at first reasonable opportunity, then it must be voluntary. So not in response of a leading or pressuring questions. So cases of this Ndakala v. the People and Anthony Moma v. the People. So here the courts have applied this exception, emphasizing that the complaint must be voluntary and at the earliest opportunity. So the courts also clarified that complaint is admissible to show consistency, not to substitute for proper evidence for the assault itself. So then the third exception is res gestae. So a statement is admissible if it was made as part of the event itself. So it must be so closely connected to the act that it can be treated as part of the same transaction. So an example of this can be where someone runs up to the bank and says, they're robbing the bank, Shanshani, things like that. So those words spoken in the moment can be admitted even though they are not of court statement. So they are part of the res gestae and the unfolding events. So then the fourth exception is accused statement upon accusation. So here of the case of Kampafuide v. the People. So when an accused is confronted with an accusation by police or anyone else, their response may be admissible as part of the narrative of the case. So an example of this can be where police arrest John and tell him, you've been identified as the person who robbed the shop. Then John can say, let's say, I was nowhere near that place. So his immediate denial is admissible, not because it proves innocence, but because it's part of the narrative of the arrest and investigation. It was part of the crime in question. So the fifth exception is identification evidence. So here we have the case of Creative the People. So where a witness made an identification at an earlier point that is consistent with their identification at trial. So that earlier identification can be admitted to support the reliability of the current in-court identification. So this is done because identification evidence is usually unreliable. So courts want to know whether the witness consistently identified the same person or whether they changed the identification somewhere along the way. So now we can go to cross-examination. So Wigmore called it the greatest legal engine ever invented for the discovery of the truth. Then in the case of Joseph Mulenga v. the People, the court stated that cross-examination has twofold objectives. The first one is to elicit information favorable to the cross-examining party. Then the second one is to cast doubt on the accuracy of the evidence given in chief. So now we can look at the right and duty to cross-examine. So cross-examination is not just a right, it carries obligation. So the case of Anayawa and Sinjabi v. the People, it was stated that a party who fails to cross-examine a witness on a matter effectively accepts that evidence. So what this means is that, for example, the prosecution witness says, I saw the accused at the shop at 3 p.m. So if the defense case is that the accused was elsewhere at 3 p.m., so defense counsel must put this to the witness. So the defense counsel may then ask, is it not that my client was at home at 3 p.m.? So failing to do so means that the court may treat the witness evidence as unchallenged. So the case of Mechanical Inventions versus Austin, it was stated that cross-examination is a powerful weapon, but one that must be used with discretion, skill, courtesy to the witness. So cross-examination is not a license for bullying or harassment. And Article 18 of the Constitution guarantees the accused right to a fair trial, so including the right to examine witnesses against them. So cross-examination is therefore constitutionally protected. So this was also seen in the case of Jones versus National Court Board, where it was stated that judges must resist the temptation to take over the questioning. So it is for the advocates each in turn to examine the witness, not for the judge to take it on himself. So a judge who interrupts or takes over may appear to be partial. So now let's look at the rule as to finality. So what you can't pursue endlessly, that's what it means. So in cross-examination, you can ask questions about almost anything relevant, but on collateral matters, the rule as to finality applies. So this rule means that if you ask a witness a question on a collateral matter and they deny it, you are bound by that answer. So you cannot call evidence to contradict them on that collateral issue. So an example of this can be, let's say you are cross-examining a witness on a robbery charge. Then you ask the witness, let's say you ask them isn't it true that you once cheated at cards? Then if the witness says no, you cannot call witnesses or former card-playing friends to testify that yes, they did cheat. So that's a collateral matter. You're stuck with the answer. So this rule is there because otherwise courts would be endless, meaning they'll have to go into mini trials about every witness past, then the court wouldn't move forward. So let's now look at the exception to the rule of finality. So the first one is previous conviction. So Section 6 of the Civil and Criminal Evidence Act provides that a witness may be cross-examined on their previous criminal convictions, and if they deny them, the convictions may be proved by formal record. So an example of this can be where a witness claims to be an honest person, then defense asks, were you convicted of fraud? So if the witness denies it, the defense can produce to the court evidence that they were convicted before. So then the second exception is inconsistent statements. So under Section 4 and 5 of the Civil and Criminal Evidence Act, so if a witness has made a prior statement inconsistent with their current testimony, the prior statement may be proved. So in example cases on this, Simon Miwa v. the People and Chiyovu v. the People. Chiyovu Kasomo v. the People. So an example of this can be where, let's say, a witness A witness says in court, I saw the accused run north. Cross-examination reveals a police statement they gave where they said, I saw someone run south. So that contradiction, can be explored and proved. So this goes directly to the credibility of that witness. Then the third one is bias or prejudice. If you can show a witness has a reason to lie, or a personal grudge, a financial interest, or relationship with a party, you may pursue this and call evidence even if they deny it. So cases on this are Thomas and David, R.V. Mendy, and so forth. So the fourth one is evidence of disability evidence of disability affecting reliability. So the case of Tohe versus Metropolitan Police Commissioner. A witness' mental condition, if it affects their ability to perceive or recall accurately, is not a collateral matter. So medical evidence can be called to show that the witness' reliability is affected by psychological conditions. So an example of this can be, let's say, a prosecution relies heavily on one eyewitness. So medical evidence reveals that witness suffers from a condition causing visual hallucination. The defense can call medical evidence on this. So this is not collateral because it goes to the fundamental reliability of the testimony. So the fifth exception is denial of reputation of untruthfulness. So if a witness denies having a reputation for untruthfulness, evidence may be called to contradict this. But however, specific acts of dishonesty cannot be proved, only general reputations of dishonesty. Okay, so now let's look at hostile and unfavorable witnesses. So you may ask yourself what happens when your own witness stands against you while they are in the box. So we have two types of problematic witnesses. The first one are unfavorable witnesses. So this is simply a witness who simply doesn't give the evidence you expected. So in this case, they are honest, but they just don't help your case as much as you hoped. So you cannot treat these witnesses as hostile, so you're stuck with the evidence they give. So an example can be, let's say you call a bystander to testify that they saw the defendant punch the claimant. Then that witness says, I saw a scuffle, but I couldn't clearly see who struck first. So this witness is unhelpful, but not hostile. So they are simply doing their best. Then a hostile witness, on the other hand, is a witness who shows no desire to tell the truth. So this is one who is willfully adverse to the party who caught them. So they're not merely giving unhelpful evidence. So cases on this are Ewa versus Ambrose. So a hostile witness is one who is not desirous of telling the truth to the party who caught them. That was the definition given in Ewa versus Ambrose. So we have the cases of Munalola v. the People, Chibinde v. the People. So the courts in these cases applied these principles to determine when a witness may properly be declared hostile. And in these cases, the courts confirmed that a judge has discretion to declare a witness hostile upon application by counsel. So what happens when a witness is declared hostile? So with the judge's permission, the party who caught that witness can, firstly, they can cross-examine their own witness. Secondly, they can put to them any prior written statements that they made. And then the third thing is that they can challenge their credibility. So an example of this can be, let's say the prosecution calls a witness who made a police statement identifying the accused. But while they're in the box, the witness can say, I don't know the accused, I never identified anyone. So the prosecutor applies to have the witness declared hostile. So the judge grants it, and then the prosecutor can now put the earlier police statement to the witness, and they can ask, did you not sign this statement identifying the accused? So this challenges the witness directly. So what you should know is that even when a witness is declared hostile, their prior statement does not automatically become evidence of the truth of its contents, but it goes to credibility of that witness. it goes to show that the witness is unreliable rather than to prove the facts in the statement. So now we can go to re-examination. So this is the final stage. So after cross-examination, the party who called that witness gets one more opportunity to re-examine that witness. So the purpose for this is that it's done to repair damage during cross-examination, and it's used to clarify, explain, or contextualize answers that were given during cross-examination. But we have limitations on this. The first one is scope. So in re-examination, it is strictly limited to matters arising from cross-examination, so it cannot introduce new topics. The second one also is no leading questions, same as examination in chief. Then the third is no repetition. So you're not allowed to simply repeat the examination in chief. An example of this can be, let's say in cross-examination, the witness was asked, "Isn't it true that you saw the accused for 2 seconds?" And the witness said yes. So in re-examination, counsel can ask, "You said you saw the accused for 2 seconds. Can you explain what conditions you were in during those 2 seconds? Was it light? Were you close?" So this allows the witness to add context to what might otherwise seem like a damaging statement. So a case on this is Kalenga v. People. So this case addressed the limits of re-examination. So the courts in this case were confirming that re-examination must be confined to matters that arose in cross-examination, not used as a second bite of examination in chief. Okay, so that's the end of it. So if you have any questions, you can leave them in the comment section, or if you think this video can help someone, you are free to share it to whoever you may.